Hi guys, and welcome to CBT Law Guides. Today I wanted to go over the estate planning trifecta. What are the 3 core estate planning documents, and why should they be included in every estate plan? Let's get started. The estate planning trifecta consists of a last will and testament, a power of attorney, and an advance medical directive. The biggest myth in estate planning by far is that you don't need it. We've all heard the reasons before. My situation's not complicated. My assets will automatically go to my children. My spouse can take over my affairs if I'm incapacitated. I'm not giving control over my life to someone right now. I'm completely fine. My family knows what I would want if I'm in the hospital. Who cares at that point? I'll be dead. And the list goes on. What many people don't realize, however, is that these scenarios aren't always the case. And even if some of them technically are correct, it doesn't mean it's going to be easy for your family. Let's look at each one in more detail, starting with the last will and testament. If nothing else, everyone should have a will. This is the document that speaks for you when you're no longer able to speak for yourself. It's not only your opportunity to list exactly which individuals you want to receive exactly which assets, but also who you would trust to handle your affairs and make sure that your wishes are carried out. And if you have children, it's also a place where you can list who you would trust the most to look after them in your absence. Think this will all happen automatically without executing a will? You might be surprised. While yes, your family are your natural heirs, not having a will makes things so much more complicated for them. One big example we see all the time is with real estate. Let's say your parents had 4 children, you and 3 other siblings. Let's say they also never executed a will. By law, when each of them pass away, you and your 3 siblings each own 1/4 of the property. Now let's say you each have 4 children and none of you execute a will. Eventually, that property will transfer to all 16 of those children once you and your siblings pass away, if they survive you. If any of the children do not survive you and also do not have a will, their share gets split even further. Now, everyone needs to agree what happens with the property or get the court involved for a lengthy and expensive partition suit. In our example above, even if everyone did agree what should happen with the property, and let's say they agreed to sell it, each of those 16 individuals will have to sign the deed and all of the associated paperwork. Still doesn't sound that bad? Let's add in some common layers of complexity. Are all of the 16 children over the age of majority? Are all 16 of them legally competent? Do you know where all 16 of them physically are? If the answer to any of these is no, then you can expect to get the court involved to determine who can sign on behalf of the minor beneficiaries or the missing heirs. As you can see, this can get very messy very easily. By contrast, had even one of those beneficiaries had a will in place, that document would have appointed an executor who could have signed on behalf of that estate's beneficiaries. See how just this one document can make all of the difference? Next, let's look at the power of attorney. This is another document that's very simple to set up and can make all the difference later on. I like to look at these like insurance policies. You're going to wish you had one when you need one. A power of attorney appoints an individual who can essentially step into your shoes to handle your affairs when you're unable to do so for yourself. They can make sure your bills get paid, your taxes get filed, sign any important legal documents on your behalf, and so much more. I know, giving someone this much power sounds terrifying. But while these documents can be, and many times are, immediately effective, there are other options available as well. They can be springing, which means they basically sit in the background until you do need it. They can also be immediately effective for your first named agent, but springing for any other successor agents, which makes it a great option for married couples where one or both parties travel a lot. We often hear, "I'm young right now, I don't need it, but I'll come back when I do." But many times, people don't remember to come back, or when they do, it's too late. Executing a power of attorney has a higher legal capacity requirement than a will. You need to be able to truly appreciate the control that you're giving over to someone else. With the will, you just need to know what your assets are, who your beneficiaries are, that you're making a will, and where you want things to go. If you've already been diagnosed with dementia, even if it's in the early stages, we will require a doctor's note before we're able to move forward. Worse, if it's sudden incapacity, like being hospitalized after an accident, or your dementia has gotten too bad, the only other option your family will have is to petition the court for a guardianship and conservatorship. To do this, they will need to hire an attorney, petition the court, involve a guardian ad litem, have a hearing, qualify with the probate office, and then file annual accountings showing every dollar and cent that goes in and out of your financial estate while they're acting as your guardian and conservator. This can take months and is expensive and exhausting for your family. When you compare this arduous process with a few meetings with your attorney and paying one fee to get the document prepared, the difference is stark. Finally, let's go over the Advanced Medical Directive. This document is similar to the power of attorney, but instead of financial decisions, it focuses more on medical decisions and preferences. Would you rather have your loved ones make decisions for you when you're in the hospital, or the Commonwealth? If the hospital has been able to locate your next of kin, the last thing you want during an already difficult time is for your family members to argue about what should happen or what they think you would have wanted. In addition to authorizing someone to make important medical decisions for you, this document can also address whether you want organ donation or anatomical gifts, whether you'd like to be on life support if you're terminally ill, it gives people access to your medical records, and so much more. As someone who practices in this area, I just wanted to share some of the problems that we frequently run into when some or none of these documents have been executed. It truly is worth the time and financial investment to get these documents into place to save your family a headache and potentially a costly situation later down the road. Whether you're just getting started with your estate plan, want to revise your existing plan, or even just want to have someone review it to make sure it's still in compliance with Virginia law and accomplishing the goals that you want it to, we're here to help. This has been brought to you by CBT Law Guides, helping you plan for the future.